Good evening, everybody. For those of you who don't know me, my name is Jim Anaya. I'm the Dean of the Law School. I'm happy to welcome you all to the annual Coen Lecture featuring Akhil Amar. I'd like to start by acknowledging the Ute, Cheyenne, and Arapaho peoples on whose traditional lands the University of Colorado is located. I'd also like to wish all of you a happy Earth Day. The namesake of this lecture series is John R. Coen, who is a distinguished member of the Colorado Bar. After his passing, his widow, Adrienne Coen, established this lectureship in 1955 in his memory. The purpose is to bring a prominent and distinguished lawyer, jurist, or scholar of law to deliver an annual lecture to the Colorado law community on a legal subject of public interest and a benefit to the profession. This year, we welcome as the 63rd annual Coen Lecturer, Akhil Amar, Sterling Professor of Law and Political Science at Yale University. As you've seen, the title of his presentation is America's First Peaceful, Just Barely, Transfer of Power. Professor Amar is a highly distinguished lawyer, teacher, and legal scholar, and is well known in the legal community. We had scheduled him to deliver the Coen Lecture last year about this time, but the onslaught of the pandemic derailed those plans, as of course they derailed a lot of plans. We had hoped to reschedule the lecture as an in-person event this semester, but unfortunately that wasn't possible. In any case, we're excited that Professor Amar is joining us this evening in this virtual platform with which we're now all very familiar. And I should note that this is the second time that Professor Amar has delivered the Coen Lecture. The first time was, and we were just talking about this, it was in the 1990s, early 1992, I believe. We're very, very happy to have him back. Professor Amar teaches constitutional law in both Yale College and Yale Law School, and has written extensively in the field. After graduating from Yale College in 1980 and from Yale Law School in 1984, he clerked for then Judge and now Justice Stephen Breyer. Afterwards, he joined the Yale faculty in 1985 at the age of 26. He is Yale's only currently active professor to have won the university's unofficial Triple Crown, which is the Sterling Chair for Scholarship, the Devane Medal for Teaching, and the Lamar Award for Alumni Service. Professor Amar's work has won awards from both the American Bar Society and the Federalist Society, and he has been cited by Supreme Court justices across the spectrum in more than 36 cases. He's frequently testified before Congress, and in surveys of judicial and scholarly citations, he is invariably ranked among the country's most cited legal scholars. He has written widely for popular publications and is the author of more than 100 law review articles and several books. You can find more information about Professor Amar's impressive career in your program. In his presentation this evening, Professor Amar will explore the history of the United States presidential transfer of power. He will feature excerpts from his brand new book, The Words That Made Us, America's Constitutional Conversations, 1760 to 1840. And he'll discuss how Thomas Jefferson came to succeed John Adams as president of the United States. As we'll hear, the events of 1798 to 1801 were far more fraught than is generally understood today. And in a number of ways, they cast an eerie light on the not entirely peaceful transfer of presidential power following the 2020 election. It's now my pleasure to welcome Professor Akhil Amar. Akhil.
Thank you so much for that very generous introduction, Jim. So great to be with you all. Since the good dean mentioned that I was fortunate enough to be the Coen Lecturer back in the early 90s, I should just tell you all that I've been married actually over 3 decades. When my wife was able to join me for that, those were some of the best memories actually we have had. And we had such a lovely time I'm sorry I can't be with you in person. I do hope in the future I can come and make up for the fact that we're only together virtually today. And it's such a pleasure and a privilege to be with you again. Thank you so much for this very generous invitation. So with that, I'm going to launch into a reading of a couple of the passages of this new book. Its pub date is May 4th. I only got my own copies from the publisher about 2 days ago. It's a big fat book. Oh, here it is. And I'll tell you maybe a little bit more about it in the Q&A. I've tried to reserve some time after the lecture to converse with you all. And the book, in fact, is all about constitutional conversation, as are parts of today's lecture. So this is once again a talk on America's first peaceful, but just barely, transfer of power. On July 14, 1798, 9 years to the day after the storming of the Bastille, President John Adams signed an American Sedition Act into law. The 1789 Parisian incident had set into motion events that ultimately toppled and killed King Louis XVI, his queen, Marie Antoinette, and their heir to the throne, the Dauphin. Adams's signature likewise led to his own ouster. But the president, his lady Abigail, and their heir, John Quincy, got to keep their heads in the transition and thereafter. On two telling dimensions, orderliness of regime change and avoidance of bloodshed, Federalist-era America showed itself vastly superior to revolutionary France. But the events of 1798 to 1801, America's first peaceful transfer of power from one presidential party to another, were in fact more fraught than is generally understood today, and in myriad respects cast an airy light on the not entirely peaceful transfer of presidential power in 2020 to 2021. Under the terms of the Sedition Act, anyone who dared to criticize the federal government, the president, or Congress risks a fine of up to $2,000 and a prison term of up to 2 years. But venomous criticism, even if knowingly false and violence inciting, that targeted the vice president was fair game under the law. Thus, in the impending 1800 electoral contest between Adams and his main rival, Thomas Jefferson, was also Adams's sitting vice president, Adams and his Federalist Party allies could malign Jefferson, but Jefferson and his allies, the Democratic Republicans, could not reciprocate with equal vigor. So just to remind you, this is an election in which the sitting president and the sitting vice president are actually going to be going after each other. And the president is going to be able to dump on the vice president, but not vice versa under the terms of the statute. So you should already be thinking, oh, Trump, Pence, they technically were running together and not against each other, but some interesting and eerie parallels. Congressional aspirants attacking congressional incumbents, as congressional challengers attacking congressional incumbents would need to watch their words, but not vice versa. Just in case the Democratic Republicans managed to win the next election, the act provided that it would poof into thin air on March 3rd, 1801, a day before the new presidential term would begin. Now, on its surface, the act seemed modest. It criminalized only false, scandalous, and malicious, that's a quote, writings with utterances that had a, quote, intent to defame, unquote, or comparable acidic motivation. The defendant could introduce into evidence the truth of the matter contained in the publication charged as a libel. This was more generous than libel law at the time in Britain, where truth was no defense. Indeed, truth could actually compound a British publisher's liability. The greater the truth, the greater the libel, because the libelee would suffer a greater reputational fall if the unflattering story was in fact true. British law was thus all about protecting His Majesty and His Lordship and His worshipfulness from criticism. It was the product of a residually monarchical, aristocratic, and deeply deferential legal and social order. British freedom of the press meant that only that the press would not be licensed or censored pre-publication. Anyone in Britain could freely run a printing press, but printers in Britain might face severe punishment after the fact if they used their presses to disparage the powerful. Back in the 1780s, Thomas Jefferson had urged James Madison and other allies to fashion a federal Bill of Rights that would go beyond English law, but not by miles. As Jefferson envisioned what would ultimately become America's First Amendment, quote, a declaration that the federal government will never restrain the presses from printing anything they please will not take away the liability of the printers for false facts printed, unquote. Jefferson evidently could live with publishers' liability for false facts printed. But what if the falsehood was a good faith mistake or a rhetorical overstatement in a vigorous political give and take? Could an honest mistake or mere exuberance ever justify serious criminal liability and extended imprisonment? Also, who would bear the burden of proof? The Sedition Act purported to criminalize only false statements, but in the 1790s, many derogatory comments were legally presumed false. The Sedition Act said the defendant could give in evidence in his defense the truth of the matter, that's a quote, but many edgy statements mixed truth with opinion and rhetoric. If a critic wrote, for example, that John Adams was a vain and pompous ass who did not deserve a second term, how exactly could the critic establish the courtroom truth of the matter? Adams erred not simply in signing the sedition law, but in mindlessly and mercilessly prosecuting and punishing, and never pardoning, men under it. He and his minions hounded tart but peaceful speakers and printers whose only real crime was dislike of John Adams, his party, and his policies, in cases whose facts were miles apart from treason, riot, or mayhem. Indeed, under the ridiculously strict standards of his own administration, a young John Adams himself should have been fined and imprisoned back in the 1760s and 1770s for his vigorous denunciations of the then colonial Massachusetts royal governor, Thomas Hutchinson. So in other words, and I'm breaking from a formal text here, Adams is a very thin-skinned guy. And when he was out of power, he had said all sorts of critical things about those in power. But now that he's in power, he's going to be very touchy. And if you're starting to think, oh, that reminds me of someone else who was recently president, that's what I want you to think. Can you spell Trump? In the first high-profile sedition case, brought in October 1798, the Adams administration targeted a sitting Democratic Republican congressman, that is a Jeffersonian, from Vermont, Matthew Lyon, for personal writings and harangues, some of them at campaign rallies. In one passage highlighted by the prosecution, Lyon had written that Adams had, quote, swallowed up every proper consideration of the public welfare in a continual grasp for power and an unbounded thirst for ridiculous pomp, foolish adulation, or selfish avarice. That's unquote. Adams, wrote Lyon, had turned out of office men of real merit and independence in favor of men of meanness. That's also a quote. Lyon had also read at public meetings a communication from a French diplomat bemoaning, quote, the extremely alarming state of relations between France and the United States, worsened by the, quote, bullying speech of your president and stupid answer of your Senate, unquote. At Congress, wrote the diplomat in words that Lyon publicly repeated, should, quote, send Adams to a madhouse, unquote. How exactly could Lyon prove in a courtroom the technical truth of these words, blending as they did fact, opinion, analysis, interpretation, and rhetoric? The jury convicted and the court sentenced Lyon to a fine of $1,000 and a 4-month imprisonment. Dozens of newspapers across the continent brought readers detailed reports of the cause célèbre. While in prison, Lyon wrote an account of his travails that the Philadelphia's Aurora General Advertiser published in early November, followed by newspapers in many other localities. The congressman vividly described his conditions of confinement. Quote, I am locked up in a room about 16 feet long by 12 feet wide with a necessary, that is an open latrine, in one corner, which affords a stench about equal to the Philadelphia docks in the month of August. The cell is a common receptacle for horse thieves, counterfeiters, runaway Negroes, or any kind of fellow, unquote. When Lyon stood for re-election from prison in December, his constituents gave him a roaring vote of confidence, returning him to his House seat. Adams thus won the first courtroom battle, but was beginning to lose the war of public opinion. A year and a half later, the last big Sedition Act trial before the election of 1800 resulted in an even harsher sentence, 9 months imprisonment. The defendant was the trashy but talented journalist, James Callender, the man who broke the Alexander Hamilton sex scandal story in 1797 and would later, in 1802, expose Jefferson's affair with his slave mistress, who was also his deceased wife's half-sister, Sally Hemings. In the run-up to the election of 1800, Callender published a campaign pamphlet, The Prospect Before Us. Callender painted in bright colors and attacked Adams for just about everything. Quote, "Take your choice then between Adams, war and beggary, and Jefferson, peace and competency." Unquote. The reign of, and this is another quote, "the reign of Mr. Adams has been one continued tempest of malignant passions." Okay, let me read that again because I want you to think about someone more recently, maybe. "The reign of Mr. Adams has been one continued tempest of malignant passions. As president, he has never opened his lips or lifted his pen or tweeted." Oh no, he didn't say tweet. I'm joking. As president, he has never opened his lips or lifted his pen without threatening or scolding, unquote. The administration's corruption was notorious. Those are quotes. Indeed, the president had appointed his own son-in-law, yes, his own son-in-law, remember that one, William Stephen Smith, to a plum federal office, surveyor of the Port of New York, thus, quote, "heaping myriads of dollars upon a paper jobber who, next to Hamilton and himself," that is Adams, "is perhaps the most detested character on the continent," unquote. So this was a pretty colorful attack on the Adams administration. Notably, Callender also blasted the Sedition Act itself and Adams's abuse of it. Quote, "The grand object of his administration has been to calumniate and destroy every man who differs from his opinions. The simple act of writing a censure of government incurs the penalties, although the manuscript shall only be found locked in your own desk," noted Callender. Here, the Sedition Act did indeed approximate mind control. Yet Adams apparently never shuddered to think about his own diatribes against Hutchinson and other government officials in the 1760s and 1770s. Finally, Callender, who showed more self-awareness than Adams on this point, connected his critique of the act to the very nature of the election year pamphlet in which his more general critiques of Adams were appearing. The act made it, quote, "virtually impossible to discuss the merits of the candidates," unquote. If a person proclaimed that he preferred Jefferson to Adams, as Callender was of course doing in this very pamphlet, wouldn't that itself be an actionable slur on Adams? Asked Callender. The Adams administration apparently agreed and prosecuted Callender in the spring of 1800 for what today looks like a rather typical, if overstated, campaign tract. Callender's 9-month sentence drew the gaze of printers and readers across the continent, just as the Adams-Jefferson race was unfolding in a series of statewide contests for electoral votes. Alongside the conviction of Lyon, Callender's case Callender's case cast Adams in an unflattering light, as did other lower profile cases. One case featured a Newark drunkard, Luther Baldwin, who made a crude joke about the president's rear end. All told, the Adams administration initiated more than a dozen, indeed one recent historian says many dozen, prosecutions under the Sedition Act and closely related legal theories. Some cases never came to trial but still captured attention. For example, the feisty printer of Philadelphia's Aurora General Advertiser, Benjamin Franklin Bache, named for his famous printer grandfather, died while under indictment, the victim of a yellow fever pandemic. Yes, there were pandemics back then. The Aurora was a high-profile anti-administration paper published in an iconic city. Going after Bache was the 18th century equivalent of a Republican president today seeking to imprison the editors of the Washington Post, or a modern Democratic president aiming to criminalize the publishers of the National Review. Indeed, Jefferson himself had secretly financed Callender, a fact which only later came to light. If Callender was guilty, why not his accomplice, Jefferson? So Adams's policies were in fact the 18th century equivalent of, say, Donald Trump trying to imprison Joe Biden in 2020 for speaking ill of Trump and supporting others who did the same. Two Supreme Court justices riding circuit had sided with Adams. But America's ultimate Supreme Court consists of the sovereign American people, who express themselves most consequentially via constitutional amendments and pivotal elections. The Adams-Jefferson contest was just such a pivotal election, and the court of public opinion ultimately sided with Jefferson and Madison, as has the court of history. The biggest problem with the Sedition Act of 1798 was its self-sealing quality. Anyone in the press who harshly criticized this horrid law, such as Callender, risked prosecution under the law itself. That's some catch, that catch-22. But each state legislature was a special speech spot. Even if newspapers risked prosecution under the Sedition Act, if they initiated their own harsh critiques of the act or reprinted other newspapers' critiques, surely they would enjoy absolute immunity if they merely told their readers what had been said in the special speech spots in state capitals, these state legislative debates. Thus, Madison and Jefferson quietly composed resolutions for adoption in the Virginia and Kentucky legislatures, respectively. Madison was by far the abler constitutional theorist and practitioner, and his version has aged better than Jefferson's. On Christmas Eve, 1798, the Virginia General Assembly denounced the provisions of the Sedition Act as, quote, palpable and alarming infractions of the Constitution, unquote. That act, more than any other, ought to produce universal alarm because this is all quote, that act, more than any other, ought to produce universal alarm because it's leveled against that right of freely examining public characters and measures and of free communication among the people thereon, which has ever been justly deemed the only effectual guardian of every other right, unquote. In other words, free speech protects all the other rights. Over the next 6 weeks, newspapers in most states reprinted or excerpted Virginia's protest. In the short run, Madison and Jefferson did not succeed in getting other state legislatures to join the Virginia and Kentucky bandwagon. But in the end, it did not matter whether the two statesmen immediately convinced a majority of state lawmakers, just as it did not matter whether they immediately convinced a majority of sitting Supreme Court justices. What mattered most in 1800 to 1801 was winning a majority of electoral college votes in the Jefferson-Adams slugfest. And that Jefferson did. When the American people, having now seen quite clearly what freedom meant to Adams and what freedom meant to Jefferson, decided between these two icons of 1776, they decided for Jefferson. But there was a catch involving palace intrigue, eerily similar to some of the strangest moments that would unfold in America 220 years later in January 2021. The backstory to this episode of palace intrigue and near mayhem in 1800 to 1801 began, fittingly enough, with the early 1790s rivalry between Jefferson and Hamilton. Who was truly Washington's who was truly Washington's prime minister. In particular, who should succeed to the presidency if both Washington and Adams were to die, become disabled, or resign. And so I'm going to tell you now a little bit about that. The Jefferson Hamilton bad blood from a decade earlier. The Constitution's vacancy clause left this question for the federal legislature to decide. That is, who becomes president if both the president and the vice president are out of commission. Quote, Congress may by law declare what officer shall then act as president, unquote. The text authorized an ex officio designation, not who, but what, not which person, but what officer, qua officer, would serve as acting president as part of his regular office. In 1791, Jefferson's partisans in Congress, led by Madison, proposed to designate the Secretary of State as the officer next in line, a move that would bolster the status of Thomas Jefferson, who then held that office, and deflate the pretensions of then Treasury Secretary Alexander Hamilton. Hamilton's congressional admirers balked. As a compromise, some proposed to designate the Chief Justice, a post then held by Hamilton leading John Jay. After bouncing between House and Senate and various committees thereof, the bill as finally adopted in 1792 placed America's top senator, the Senate President pro tem, first in line, followed by the Speaker of the House. So that's similar to the today's statute, but reversed. Today it's under the statute of 1947, Speaker of the House, and then Senate President pro tem. Then it was Senate President pro tem, and then Speaker of the House. Alas, this was unconstitutional. And by the way, I believe the current succession statute is unconstitutional, and we can talk about that in Q&A if you like. As Madison and others persuasively pointed out, senators and House members were not, strictly speaking, officers within the letter and spirit of the Constitution's vacancy clause. Only judges and executive officials, those who acted upon private persons and were not mere lawmakers, were proper officers for succession purposes. Indeed, Article 1, Section 6, expressly prohibited sitting Congress members from holding executive or judicial office. Quote, no person holding any office under the United States shall be a member of either house during his continuance in office, unquote. All this set the scene for post-election drama in 1800 to 1801. The Democratic Republicans won the election with 73 electoral votes for Jefferson compared to 65 for Adams. But the fledgling party blundered slightly. Under the original Constitution, there was no separate balloting for the vice presidency. Rather, each member of the Electoral College cast 2 votes for president. The top vote getter, if backed by a majority of electors, would win the presidency, and whoever came in second in the presidential balloting would become vice president. The Democratic Republicans aimed to catapult Jefferson into the presidency and his running mate, New Yorker Aaron Burr, into the vice presidential slot. But every Jeffersonian elector also voted for Burr. The party should have designated one elector to throw away his second vote to ensure that Jefferson would outpoint Burr, but somehow failed to do this. There was thus a tie at the top between Jefferson and Burr, a tie that would need to be untied by the lame duck, Federalist-dominated House of Representatives. Now, the House could surely pick Jefferson, the only proper outcome thought the Jeffersonians. Indeed, that's what the House ultimately did, thanks in no small measure to Hamilton's emphatic appeals to congressional Federalists on behalf of Jefferson. Hamilton told his correspondents, the people he was writing letters to, that despite his own fierce feuds with Jefferson and the personal dislike that each man had for the other, the former Secretary of State was an honorable and capable public servant committed to his country's welfare. Once in power, Jefferson would, Hamilton hoped, eventually see the Hamiltonian light and govern in a way that would protect America's vital interests at home and abroad. By the way, Hamilton guessed right on this in general. Hamilton told his Federalist allies that Burr, by contrast, was a charming but corrupt wild card who might sell the nation out to the highest bidder merely to line his own pocket. So Burr was financially corrupt. Still, the Federalist-dominated Congress could lawfully pick Burr. Many Jeffersonians considered the scenario underhanded because none of Burr's electors had truly wanted to see him president. From a legal point of view, however, Burr's votes were no different from Jefferson's. If Federalists actually preferred Burr, why shouldn't he win as the consensus candidate? After all, had Federalist electors known long in advance that Adams was a lost cause, they could have chosen to vote for Burr in the Electoral College balloting in the several states. Had even a single Federalist so voted, Burr in fact would have received more electoral votes than Jefferson, and thus would have won under the strict letter of the rules. How was the matter any different if Federalist House members opted to back Burr over Jefferson when allowed to untie the Electoral College tally? If this flipping of their ticket irked Jeffersonians, they had only themselves to blame for having picked Burr as their second man. After all, even if Burr were selected by the Federalist-dominated House, nothing would stop President Burr from resigning in favor of Vice President Jefferson. Easier still, nothing stopped Burr from publicly urging all House members to endorse Jefferson, mooting any need for post-inaugural heroics. What, though, if the House failed to pick either Jefferson or Burr? This sounded lawless, but it wasn't really. The Constitution required the House to untie the election under special voting rules reminiscent of the old Articles of Confederation. Each state delegation in the House would cast one vote, and the winner would need a majority of state delegations. If a state delegation were equally divided or abstained, its vote would count for 0, not 1/2 of each candidate. It was thus imaginable that neither Jefferson nor Burr would have an absolute majority of state delegation votes in the House. 9 out of 16. There were 16 states back then. So 9's a majority, when Adams's term expired at the end of March 3rd. If if neither gets to 9, neither Burr nor Jefferson, could Adams simply hold over for a short period past his constitutional allotted 4 years? For, say, a month? For a year? For 4 years? Or would the Succession Act spring to life when Adams's term expired, allowing the Senate's president pro tem to become the president of all America? Even if that person were a Federalist, the Federalists had a comfortable majority in the lame duck Senate. The new Senate would be closely divided. What about the argument that the Succession Act was in fact unconstitutional? Enter Horatius, that's a pseudonym, stage right. In a pair of newspaper essays initially published in early January 1801 in the Alexandria Advertiser and widely reprinted in both the capital area and beyond, the anonymous Horatius offered a cute way of untying the presidential knot. That's K-N-O-T. So he's going to untie the knot. Horatius argued that the Succession Act was indeed unconstitutional. The lame duck Congress should thus enact, and the lame duck president, Adams, should sign, said Horatio, a new Succession Act designating a proper officer to take charge after March 3rd in the event of a Jefferson-Burr House deadlock. Horatius did not explicitly say what officer should now fill the blank, but the obvious choice, legally and politically, for the lame duck Federalist was the Secretary of State. After all, he was the highest ranking officer, except for the arguable possibility of the Treasury Secretary and the Chief Justice. But the position of Chief Justice was vacant in early January. And although Horatius said none of this, he didn't need to, the sitting Secretary of State in early 1801 just happened to be the Federalist's most popular and able politician, Jefferson's old rival and first cousin once removed, John Marshall. It was an elegant and brilliant idea, a political and legal stroke of genius, evil genius from a Jeffersonian perspective. But whose genius idea was it to crown John Marshall? Who was this Horatius? Most likely, according to modern scholars, John Marshall himself. Even if Marshall was somehow not Horatius, Marshall surely agreed with Horatius. In mid-January 1801, James Monroe sent Jefferson a letter bristling with concern. Monroe was a Jefferson ally. It is said here, this is a quote, it is said here that Marshall has given an opinion in conversation that in case 9 states should not unite in favor of one of the persons chosen by the Electoral College, that is Jefferson or Burr, the legislature may appoint a president till another election is made, and that intrigues are carrying on to place us in that situation, unquote. In an earlier letter to Jefferson, Monroe had identified Marshall as a likely beneficiary of the Horatius Gambit. Quote, some strange reports are circulating here of the view of the federal party in the present desperate state of affairs. It is said they are resolved to prevent the designation by the House of Representatives of the person to be president, and that they mean to commit the power by a legislative act to John Marshall or some other person until another election, unquote. And if this isn't beginning to conjure up images of January 6th, wow, what would? January 6th of 2021. Jefferson responded by treating the situation as 1776 all over again, rallying his troops and rattling his saber, just like in the American Revolution. In mid-February 1801, he told Monroe that, quote, that he, quote, thought it best to declare openly and firmly, one and all, that the day such a succession act passed, the Middle States would arm, and no such usurpation, even for a single day, should be submitted to, unquote. This was not casual chit-chat. In 1801, Monroe was the sitting governor of Virginia, which of course bordered on the new national capital. Jefferson was telling Monroe to ready his militia to march on Washington, D.C. with weapons, and Monroe was listening carefully. Like, wow. Jefferson's were the words of a sloppy, rash, and trigger-happy politico. What was his legal warrant for threatening to incite states near the national capital, middle states, to take up arms against the central government? The Horatius Gambit was surely sharp dealing, given that it aimed to give the presidency to neither Jefferson nor Burr, but how was it illegal? The Jeffersonians themselves had created the mess that Horatius slyly offered to tidy up. After all, Jefferson himself and his party had picked the ethically challenged Aaron Burr to be, under their own plan, a heartbeat away from the presidency. If Burr were supremely honorable, he could simply declare, publicly and unequivocally, that he would not accept the presidency, even if offered the post by the lame duck Federalist-dominated House. If Burr had made such a clear and public declaration, it's impossible to imagine that the House could have deadlocked. Jefferson would have become the president by a process of elimination, much as if Burr were dead. Imagine, say, an early 1801 duel in which Hamilton killed Burr. To his credit, Burr did not actively lobby in his own behalf. He did not hasten to Washington City to meet with House members, nor did he make any promises by letter or via intermediaries in exchange for House votes. But he did not, as he easily could have done, emphatically and openly disavow willingness to be selected over his senior partner. 4 years earlier, Jefferson had acted with more modesty when he had faced a remarkably similar situation. In mid-December 1796, he wrote a letter to, this is when he was initially running against Adams, 1796. He wrote a letter to his campaign manager, Madison, that ended up yielding enormous political dividends. If, upon the unsealing and counting of electoral college ballots in early 1797, he and Adams ended up tied in the contest to succeed the retiring George Washington, thus obliging the House to break the tie, he wrote, quote, I pray you, this is Madison, I pray you and authorize you fully to solicit on my behalf that Mr. Adams may be preferred. He's always been my senior from the commencement of our public life, and the expression of the public will being equal, that circumstance ought to give him the preference, unquote. As the events unfolded, Adams ended up with an outright majority over Jefferson in the Electoral College tally of 1797, rendering Jefferson's sacrificial offer moot. Adams himself learned of Jefferson's letter and was charmed. In an exultant note to Abigail written on New Year's Day, 1797, John regaled his wife with imagined and inflated details of Jefferson's admiration and deference. And Adams is full of himself, and if you can imagine someone else these days who's full of himself, please do so. This is what Adams writes. So many compliments, so many old anecdotes. Dr. Benjamin Rush met Mr. Madison in the street and asked him if he thought Mr. Jefferson would accept the vice presidency. Mr. Madison answered there was no doubt of that. Dr. Rush replied he had heard some of his friends doubt it. Madison took from his pocket a letter from Mr. Jefferson himself and gave it to the doctor to read. In it, Mr. Jefferson tells Mr. Madison that he had been told there was a possibility of a tie between Mr. Adams and himself. If this should happen, says he, that is Jefferson, I beg of you to use all your influence to procure for me, Jefferson, the second place. For Mr. Adams's services have been longer and more constant and more important than mine, and something more in the complimentary strain about qualifications, etc. End quote. Perhaps Jefferson in late 1796 knew all along that Adams had more votes, and the letter to Madison was a brilliant ploy designed mainly to flatter Adams and put him off guard. If so, it worked. Or perhaps Jefferson meant everything he said, which was less than Adams recounted. The tale grew in the telling. Either way, it's notable that Aaron Burr did not follow in Jefferson's deferential footsteps, even though Burr in 1800-1801 had infinitely more reason to yield to a senior partner and teammate, Jefferson, than Jefferson in 1796 had to yield to his old friend, but now rival, John Adams. On Wednesday, February 11th, 1801, Congress met in the new capital city of Washington, D.C., to unseal the presidential ballots that had been cast by electors in the several states. So this is like the January 6th moment, unsealing the ballots. Per the Constitution's explicit provisions, the Senate's presiding officer, that is the incumbent vice president, Thomas Jefferson himself, chaired the proceedings, just like we saw Pence chair the proceedings. As expected, there was a tie at the top, 73 votes for Jefferson and 73 votes for Burr. The House immediately began balloting by state delegation. House rules said the House, quote, shall not adjourn until a choice shall be made, unquote. All through the night and the next morning, the House voted over and over, but neither Jefferson nor Burr could reach the requisite 9 states out of 16 total. After 28 continuous rounds of balloting, the exhausted legislators broke off shortly after noon on Thursday to get some sleep. Friday the 13th brought no resolution, nor did Saturday. Still nothing when Congress reconvened on Monday the 16th. Adams's term of office was due to expire on Tuesday, March 3rd, a mere fortnight away, so just a couple of weeks away. If the impasse continued, would Adams audaciously, illegally, hold over past his allotted 4 years? Or would the lame duck and electorally repudiated Federalist Congress in its final hours ram through a new Sedition Act a la Horatius, crowning Marshall ex officio as the acting president, either in his capacity as Secretary of State or in his new and additional role as America's Chief Justice? In the meantime, he's been confirmed as Chief Justice. For the last month of the Adams administration, he wore both an executive and a judicial hat. That is John Marshall. If Adams or Marshall took steps to act as president on March 4th, would Jeffersonian middle state militias in Virginia and Pennsylvania respond with force as threatened? Would the self-proclaimed acting President Adams or Marshall counter with federal military force? Whom would the federal military salute? Would Federalist New England militias mobilize and march south? Would Hamilton try to jump into the fray? In the late 1790s, he was commissioned as a high general, second in command to George Washington, in anticipation of possible military conflict with France. With the irreplaceable George Washington no longer alive to calm the country and rally patriots from all sides to his Unionist banner, would the American constitutional project ultimately collapse in an orgy of blood and recrimination, like so many Greek republics of old and the fledgling French Republic of late? These and other dreadful questions darkened the horizon in mid-February. And then, suddenly, As if a strong blast of fresh air abruptly swept across the capital city, the impasse ended. On the 36th ballot, on the afternoon of Tuesday, February 17, enough House members changed their minds to swing the election to Jefferson by a vote of 10 states to 4, with the remaining 2 states professing neutrality. Most historians believe that Jefferson gave certain assurances to fence-sitting Federalists. Jefferson denied having made any promises, but he was a master wordsmith. His carefully crafted statements of intent, as distinct from promises, had sufficed. Thus, various Federalists crowned Jefferson with the expectation, confirmed by winks and nods from Jefferson and his authorized intermediaries, that he would govern as a moderate. On March 4, 1801, America's new Chief Justice administered the presidential oath of office to his rival and kinsman to complete the nation's first peaceful, transfer of power. Adams was not there to witness the event. Earlier that day, he had left the capital city on a coach bound for his family homestead, brooding about what might have been. And with that, if that brings to mind certain images, it's meant to. So with that, I conclude the formal part of my presentation. Look forward to conversing with you, hearing from you, hearing your comments and questions. Thank you so much for the great honor of being allowed to address you a second time.
Thank you. That was really fascinating presentation, and really does conjure up the account. Surely does conjure up images of the events surrounding the 2020 election, and of course what was happening in the early part of this year, particularly January 6th. If I could take the first question, I'm just wondering if you, as you look back at history, and you've obviously compared or conjuring up comparisons with recent history, recent events, which episode or which set of episodes do you think most imperiled democracy?
Well, of course, the Civil War, which is beyond the scope of my current.
Right. No, I mean as between the two, between the 1881 election and the 2020 election.
Oh, as between those two.
Yeah, sorry.
That's hard. On the one hand, the system was so much more fragile at the beginning. We didn't have the traditions. And America is a puny place on the edge of civilization, being polarized by the two great powers, England and France. Think of like the Cold War, and we're just a sort of little satellite regime on the edge of a kind of a Cold War between the two great world powers. So on the one hand, it was so much dicier then because we hadn't quite fully consolidated the system. On the other hand, even though I have some issues with John Adams, and I'm going to have issues later in the book with Thomas Jefferson, especially about slavery, they were not perfect, but they were undeniably great men who had lifetime records of extraordinary public sacrifice and service, extraordinary intellects and deep patriots. And the truth is, I don't think any of that is true of Donald Trump. I think he was it was and is, I'm being honest, a singularly malignant and unprecedented force in the American presidency. We have never had a president like, we've never had a presidential candidate shrieking, lock her up, lock them up, of opponents. So I did not sleep well for 4 years. For 4.5, because I saw Trump coming, and I thought he was more likely to be elected than most of the people around me who were living in a little bubble. And so that made that more parlous because, you know, I think he's deranged in certain ways, truthfully, and in it only for himself, and therefore a more mortal threat to the Republic than the Republic was shakier back then, but the two leaders were much more solid. Today, the republic is more solid, but this one guy is very, and I don't think that of the entire Republican Party. I supported publicly candidates to the Supreme Court that President Trump nominated, all the rest. So this is a point just about one person and his craziness.
Interesting. And as you were describing the Sedition Act of 1798, I was thinking, well, what if such an act were availed to the recent president, were available to the recent president?
Right, which is why I want my friends on the left as well as the right to really value free speech and protect it, even of those that they might not agree with, because it's so important that people across the spectrum absolutely hold fast to robust, uninhibited, wide open freedom of expression.
Great. We have some interesting questions coming in. Michael Shangren asks, why do you think the current presidential succession statute is unconstitutional? Could you elaborate?
Thanks for asking. It gives me a chance to plug a free podcast that I have. It's on my website. Can I do a share screen? Would that be okay? Mm-hmm. So let's just do a share screen here. And the website, just gonna clear. This is me and my friend. You've heard a lot about Hamilton, so this is me and my friend Lynn Miranda here hanging out, and he's one of the co-dedicatees of the book, as is my friend Neil Katyal over here. But let me just open up AkhilAmar.com, which is a website that I recently created. And so if you just go AkhilAmar.com, you'll see this website. And there's a podcast, which is punningly called America's Constitution. It's a weekly podcast. It's free. And actually, so last week we had a great interview with Bob Woodward, for example. But when you go to this podcast, one of the episodes, I'm going to try to figure out which one, is all about the unconstitutionality of the Succession Act. And I think we counted, I counted 16 or 17 or 18 different ways in which I thought it was unconstitutional. Let me try to remind myself which episode it was. But I'll just mention 3 or 4 right now. But in a nutshell, yes, succession inquisition, how America screwed up presidential succession and then fixed it, sort of, and then screwed it up again, and how to fix it. So this was a free podcast. You can get on Stitcher and Spotify and Apple iTunes, all the rest. We uploaded it on February 24th. It's episode number 7. So if you want, the long answer to this very good question, go check out that podcast. But in a nutshell, the technical answer is only officers are eligible for the presidency, and House and Senate members aren't officers. Cabinet people are officers. But today, just think about the following. You vote for, let's say, Ronald Reagan, and you end up with Tip O'Neill, who's a liberal Democrat. You vote for Barack Obama, and you end up with John Boehner. It makes no sense. That's an assassination incentive waiting to happen if you vote for people of one party, and you end up with folks of the other party. There are 16 other reasons, but technically they're not officers, and functionally they having this shift is a kind of regime change that's very dangerous and therefore an assassination incentive. One of the reasons we changed the rules of presidential election, because it was destabilizing to have Adams as president and Thomas Jefferson as vice president in this, because they actually were opponents. We changed the rules in the 12th Amendment precisely so you could have actually running mates. So the succession law is in deep tension with the founding document, which says officer, the 12th Amendment, which is about teammates. So if you don't get the president, you get actually his hand-picked assistant, and if not him, you get the next hand-picked assistant, kind of apostolic succession. It's inconsistent with a still later amendment, the 25th Amendment, that basically envisions nice close handoffs back and forth. So you can hand off the presidency even for an hour if you're undergoing a colonoscopy, or a day to your VP, and then get it back. You can't do that actually with the Speaker of the House, because if the Speaker of the House takes over the presidency, even for a nanosecond, they've got to give up their House position and their speakership, which makes no sense if it's just a colonoscopy one day handoff. So I ended up identifying 16 or 17, maybe 18 different ways in which this is unsound and unconstitutional. But just to give you three, again, they're not officers. Point 4, they're not officers. The 12th Amendment is about actually presidential, vice presidential teamwork. That's what the 25th Amendment is all about. And in fact, just temporary handoffs back and forth. And the party, this is an assassination incentive, really, if you can go from conservative Republican president, vice president, to liberal Democrat, or vice versa. Just very deeply destabilizing. I should also tell you, actually, the speakers of the House generally are utterly unfit to be present. They don't know about the world at all. It should be the Secretary of State, or you could have a designated hitter. You could have a special office only to act as president, and it could be like a former president. To take over that, that office, or former vice president who knows how to handle the situation.
Yeah, I got to say, I find that view somewhat persuasive, but unsettling with our what I think we pretty much assume to be settled understanding of.
And because it's not so. I promise you, Pelosi and Pompeo would have been fighting over this if something had happened to Biden. That's why I was really losing sleep about this. But let me put it a different way. 2022 off-year election, highly possible the Democrats will lose seats. Most presidents do 2 years after. So if it's Kevin McCarthy, who's the Speaker of the House, in 2 years, people are going to say, "Oh my God, Akhil, you were so totally right." And Kevin McCarthy shouldn't be it because we voted for Democrats for 4 years. That's what we should get. And also, he shouldn't get it because he's utterly unfit to be president. And that's been true of most speakers of the House. That's definitely true of John Boehner. I'm not trying to be partisan. The only Speaker of the House who actually is remotely presidential in recent years was Newt Gingrich.
Right.
In fact.
Right.
And I'm not a Newt person, but at least he had like a big enough vision and understanding of the world.
Yeah.
Kevin McCarthy's a joke.
Yeah. Well, without getting
so is John Boehner. No, and what are you talking about? Denny Hastert? Are you freaking serious? So that I go through all of that in the podcast. Speakers of the House are not presidential timber.
Right. I think we have time for one more question. I think this is quite interesting and relevant to your talk. Jeff SS asks, can you comment on voting requirements back in 1800, i.e. who could vote, were they required to register, et cetera? Did the Electoral College work differently than it does now?
Well, it worked differently in that if you come in second for the presidency, you were vice president, and that was changed by the 12th Amendment. Not everyone got to vote at the founding. Each state set its own qualifications, and the words "right to vote" didn't yet appear in the Constitution. Today, they are in 5 different places in the Constitution: 14th Amendment, Section 2, 15th Amendment, 19th Amendment, 24th Amendment, 26th Amendment. But because of slavery and race at the founding, there were not as robust a set of commitments to a broad franchise back then as there were today. Women didn't vote. Blacks in many places, free blacks did vote, but not everywhere. There were property qualifications there. There were religious qualifications in some states. If I could, Jim, just with your permission, I give you lots and lots of data on this stuff in the new book. If you're interested in how actually the system evolved for the first 80 years of the American experience, from 1760, way before the Revolution, through the Declaration of Independence and the adoption of the Constitution and the ratification of the Bill of Rights and the Louisiana Purchase and all the way up through the age of Jackson, where Blacks who began by having certain rights lost them. Many more Blacks were allowed to vote at the founding than by 1830. So franchise, and this is the answer to the question, for whites expanded in the age of Jefferson and Jackson, and for Blacks contracted. I tell the story of the Native American experience, Worcester versus Georgia, since you mentioned a Native American land as the site for the current University of Colorado. So if you're interested in history, in the story of America, and I think we have to, because if we lose that, then we don't know who we are as a people. What we have in common is the Constitution and our history. And if you found these stories interesting, there are lots more of them in this book. You can pre-order it now if you like. Actually, you can get a better price on Amazon now than you might after publication. It's being published in 2 weeks. This is the first time we've actually talked about the book, which is why I'm so enthusiastic. But if you want answers to stuff, historical questions like that, there's a lot of stuff like that in the book.
Thank you, Amar. Thank you for sharing us parts of the book, sharing with us parts of the book. It sounds like a fascinating piece of work, and I certainly look forward to seeing more of it. And unfortunately, we have to end it there. Sorry to those whose questions weren't able to get to. Thank you again, Professor Amar, for a fascinating talk and for making us think about the past in relation to our current experiences in a provocative way. We wish you all the best of luck with the book, and like I said, I personally look forward to seeing it on my desk. And thank you all for joining us for this year's Coen Lecture. By next week, you'll receive an email with the link to the presentation and survey so you can share feedback. Our CLE approval is still pending, and so, but Colorado attorneys, you will receive a link for the CLE affidavit for you to fill out, and that the CLE should be approved. Again, thank you so much, Amar, Professor Amar. Great to have you with us once again, and hopefully see you in Boulder in the not too distant future. Thanks, everybody. Have a great evening.